seems okay. Thank you so much. So welcome everyone. Good morning, good afternoon from where you're following. Welcome to this event organized by the African Competition and Consumer Protection Center, which is simply a YouTube channel where we provide a platform to discuss competition and consumer protection issues as they relate to Africa, and also as they relate to other regions, especially the European Union, in order to inform and draw lessons from experiences from different countries. So today we are going to discuss a very important topic on gatekeeper power, especially in the digital marketing system. And I'm very excited to have Alba Ribera with us today. I'm a very keen follower of what she writes, what she blogs about, especially in digital market regulation. And when I read her papers, I was really excited and very excited to meet her during the ASCOLA conference in Wolfsburg in Germany that was held this year. So Alba is a PhD student in competition law at University of Carlos III of Madrid. She has a special focus on competition law in digital markets and data regulation, and also protection of fundamental rights. She's a PhD student who is preparing to defend her PhD soon this year in September. And she has a broad expertise in competition law enforcement. She's also a lecturer in competition law at Universidad of Villanueva, and she has previously worked with the Spanish Competition Authority, and she also does a lot of editorial work, especially at the CLUA competition blog, and also at the Journal of European Competition Law in Practice. So Alba, let me give you the chance for you to take us through the topic of today. Welcome.
Thank you, Bella. And first of all, I also wanted to thank you for the invitation to participate in this forum and to discuss tech regulation in Africa. So now I'm going to share my slides. Okay, let me know if you see them. And in the next few minutes, I'll also guide you through the concept of asymmetrical regulation, as well as the interpretation of the gatekeeper designation process performed in Europe, namely in the European Union. Later on, I will also address some of the ideas on this same topic of designating gatekeepers, or if you want to adopt any other wording, also extracted from the letter of the law of both regulations, the protocol to the agreement establishing the AfCFTA on competition policy and the draft COMESA competition and consumer protection regulation. So the main difference between asymmetrical regulation and the application of competition law lies in their scope of application. In principle, competition law and regulation apply to all sectors of the economy, regardless of the industry and the sector concerned. Asymmetrical regulation, however, does not apply to all other undertakings in the same fashion. Instead, it is aimed at applying only to undertakings which embody characteristics that differentiate them from regular economic operators. The aim of these asymmetrical regulations is to therefore curb the power of particular undertakings facing specific problems for competition. In the area, particularly of platform regulation, these problems stem from network effects, the tipping of markets, or feedback data loops generating artificially generated competitive advantages in favor of the most prominent or most dominant players in the market. These predominant economic operators in the tech sector are, however, not defined as stemming from the concept of market power or dominance, since both concepts entail that the competition authority must perform a time-consuming exercise of defining the relevant market. In parallel, it is also quite questionable whether the exercise of this definition of the relevant market may capture with sufficient accuracy the competitive dynamics of digital platforms. On the slide, you'll find the different ways in which tech regulations across the world term these distinct operators. Section 19A of the German Competition Act applies to undertakings with paramount significance across markets. These rules, incorporated into the existing national competition law regime, Germany, were adopted in 2021 and are now fully applicable for the undertakings meeting the standard. Moving forward, the Digital Markets Act, or the DMA, captures gatekeepers defined under the regulation with reference to the services that they cater to the market. Those are the core platform services that we will be talking about. The DMA was adopted in 2022 by
Alba, I don't know if we have a problem with your audio.
Okay. I'm going to put on my headphone there. Okay. Is this better, Bella?
Yes.
Yes, it is.
Okay. So as I was saying, the Digital Markets Act was adopted in 2022 by the European Union, and the application of its substantive obligations was triggered in March 2024. Then, following the steps of both the German and the European Union, the UK and Japan have also adopted their own rules aimed at capturing the phenomenon of these dominant platforms via, on one side, the Digital Markets Competition and Consumer Act, the DMCC, which will enter into force in autumn 2024, as well as via the Japanese Act on Promotion of Competition for Specified Smartphone Softwares that it will enter into force in late 2024. Similarly to the DMA, the DMCC also captures undertakings with a strategic market status, whereas the Japanese legislative development does not really go and term those operators in any fundamental way, but only with reference to those services that they cater, the specified smartphone softwares, which are particularly aimed at capturing the Android and Apple mobile ecosystems. All these rules have something in common. They rely on the designation process. In this regard, they first establish the narrow scope of undertakings they are referring to via an explicit act designating them, or a designation decision, and then their obligations kick in shortly after. Within this first wave of digital regulations, all of them apply their designation in one of two ways: via quantitative means or via qualitative means. For instance, the German Section 19A introduces an exclusively qualitative designation. In other words, undertakings subject to those rules are narrowed down by the German Competition Authority via considerations that are not based on figures. That is, that they are not designated based on their bigness, but, for example, on the grip that they bear in the market, such as the dependencies that they generate or the data that they may access in their operation. As well as we'll also see in the following slides, the DMA functions based on two types of designation: the quantitative and the qualitative designation. Depending on the type of designation the European Commission applies, legal presumptions may also operate into the analysis or not. 7 gatekeepers, and you'll find those in the slide, and 24 core platform services have been designated according to the legal requirements set out under the DMA. Moreover, the DMCC also adopts a mixed type of analysis of both quantitative and qualitative considerations by demanding that these gatekeepers and these undertakings bearing strategic market status, or SMS, must have first a UK presence. Then they must also surpass a turnover threshold, aside from having a substantial and entrenched market power and holding a strategic significance in respect of digital activities. At the other end of the spectrum, the Japanese regulation also works on the premise of solely a quantitative designation operated by the competition authority, although the legislative development has not yet fleshed out what those thresholds will be and how the competition authority will apply them in practice. So turning back to the DMA, for an undertaking to fall within the scope of the regulation, it must, on one side, first provide a core platform service and must meet the characteristics of a gatekeeper. Those characteristics are those of substantiality, criticality, and durability. First of all, an undertaking's services must bear an impact on the internal market. Then the European Commission must also demonstrate that that particular undertaking is an important gateway for business users to reach end users. And finally, it must also hold an entrenched and durable position with regards to that same service. There are, in this aspect, two main pathways that the DMA establishes to designate an undertaking according to these requirements. The most straightforward and perhaps the simplest to understand is that of the qualitative designation under Article 3.8 of the DMA. The European Commission can decide based on qualitative criteria, such as, for example, the extent of multi-homing or network effects embedded within a service, that that particular undertaking should merit to be captured via the DMA. The European Commission, however, has only designated via this means Apple's iPad OS. And the second work stream of designation is that of the quantitative designation. These requirements of substantiality, criticality, and durability are applied in relation to a quantitative presumption. In other words, if the CPS overcomes three sets of thresholds corresponding to these requirements, in a similar vein to, for example, what we could find in merger control, then the CPS is presumed to remain captured by the DMA. If the gatekeeper does not oppose that view presented by the European Commission, then the CPA is designated and the provisions applied to it in the following 6 months to the designation decisions. However, if the gatekeeper fundamentally disagrees with the Commission about the application of those presumptions, because, for example, they entail a mismatch between the economic and the legal reality, then the gatekeeper may also rebut that same presumption. In principle, recitals 23 and Article 3.5 of the DMA indicate that if the designation is operated via quantitative thresholds, the arguments the gatekeepers may present to the European Commission should also bear a quantitative nature. Once the rebuttal of that presumption is operated, then the European Commission has two different options. First, it may not accept it, and thus the compliance of the obligations will be triggered in any case in the following 6 months. For example, this was the case for gatekeepers such as ByteDance and Facebook with respect to its Facebook Messenger. Or on the contrary, if the Commission does accept the rebuttal, then it can trigger a market investigation to determine whether those same arguments hold tenable within the economic reality. So this is the legal outset of the designation process on the merits of the DMA's provisions. Aside from, we also have an additional provision ingrained into this first implementing regulation to the DMA that compels gatekeepers to delineate their services. That is to say, the European Commission shifts the burden of the responsibility to the gatekeepers to tell apart whether, for example, Google search or Google shopping can be differentiated in any fundamental manner. Along the way of this process, the European Commission had to also consider how to apply or how to respond to false positives and false negatives that went into the designation process. The DMA establishes under Article 3.5 the gatekeeper's capacity, as we have said, to rebut the European Commission's application of that quantitative presumption based on what it calls exceptional circumstances in which the relevant CPS operates in. 10 different CPSs, core platform services, managed to successfully rebut the presumption so that the DMA does not apply to them. For instance, that is the case for Alphabet's Gmail or Microsoft's Edge. Depending on the type of considerations that the arguments that the undertakings sought to put forward, the rebuttal operated via different procedural mechanisms. In some cases, the rebuttal operated directly, whereas in others, the European Commission triggered this market investigation that we have been talking about to check whether those arguments were backed by the economic reality or not. On the other side, although some of the undertakings sought to put forward these arguments to rebut the presumptions, they did not successfully manage it, such as the case as ByteDance's TikTok that we'll be also talking about later. On the side, however, of the false negatives in the designation process, the DMA also provides for the qualitative designation of the CPSs. This type of procedure is also applied for those CPSs, core platform services, that do not satisfy the thresholds relative to the quantitative presumption, but that they do meet the legal requirements to be captured by the regulation. The line of reasoning that went into designation in this fashion is therefore qualitative in nature as opposed to quantitative. For instance, the European Commission designated via qualitative means Apple's iPadOS by demonstrating it was an important gateway for business users to reach end users based on 5 particular reasons. Namely, for example, the number of end and business users of the service, the degree of their lock-in of both end and business users, and the manner in which Apple could leverage its ecosystem, as well as the network effects exhibited by iPadOS, as well as its scale effects. Against this particular background, therefore, the services captured by the DMA are those displayed in the table. So not all of the services that all of these gatekeepers cater to the market are captured by the regulation automatically. As you'll see also from the left-hand side of the slide, the European Commission, although it is included within the list of these core platform services under Article 2 of the DMA, decided to not designate any service of the gatekeepers relating to virtual assistants or cloud computing services. And moving forward to the second section of the presentation, on the 10th of July, the General Court of the European Union issued its first ruling relating to how the European Commission conducted its designation process. In particular, the appeal revolves around the European Commission's designation of ByteDance's social networking service, TikTok. The now designated Gatekeeper argued on its appeal that the European Commission had not interpreted the legal requirements of the designation process in a consistent manner due to 2 main reasons. On one side, ByteDance put forward that the European Commission was wrong outright rejecting all of its arguments when seeking to rebut the effects of the quantitative presumption. On the other side, the undertaking also set out that it had sufficiently demonstrated that it did not meet the legal requirements set out to be designated under Article 3.1 that we have seen earlier of substantiality, criticality, and durability. Therefore, ByteDance sought to annul that decision, and thus it also sought to annul its own designation as a gatekeeper. To do that, the undertaking also submitted a request for its appeal to be examined under the expedited procedure and that the General Court accepted. Although it is quite unusual, the General Court issued its ruling in the time span of 8 months since the appeal was first put forward by ByteDance on November 2023. On top of that, ByteDance also tried to seek the designation decision's suspensory effects via seeking interim measures, so to avoid the compliance deadline set out for March 2024. The president of the General Court basically denied any of those grounds and deferred to the European Commission's analysis and did not grant those interim measures because ByteDance did not meet the legal standard on the side of the measures urgency to avoid any major damage to it when compelled to apply the DMA. The General Court, therefore, in July, finally issued its main ruling against all of this background. The court introduces the ruling in a quite surprising way by recognizing the validity and the legitimacy of the European Union's intervention via the DMA. By this token, the European General Court recognizes that the Commission, in pursuing its objectives of contestability and fairness, has designed a separate instrument to EU competition law to that effect. Therefore, different legal requirements and legal assessments go into the DMA's analysis. Getting down to the nitty-gritty of the court's findings, the General Court first went on to analyze whether the European Commission applied the correct legal standard in its designation process. For ByteDance's designation, it applied the quantitative presumptions embedded in Article 3.2, those of substantiality, criticality, and durability, and considered that it did not meet simultaneously the threshold of intervention required for the rebuttal of the presumption that would exempt it from being captured by the DMA. Article 3.5, and that is the article corresponding to the rebuttal of the quantitative presumption, reads that the gatekeeper must submit sufficiently substantiated arguments that manifestly call into question the application of the presumption. In a similar vein, recital 23 seems to also indicate that only qualitative arguments can go into rebutting the presumption in this fashion. However, ByteDance brought forward different arguments to try to rebut the presumption, not necessarily based on quantitative reasons, which we'll also look at later. ByteDance argued, therefore, that the European Commission had directly rejected those arguments for the rebuttal due to their qualitative nature, and that they were not appraised on their own merits. The General Court, however, disagrees and does away with the difference between quantitative and qualitative arguments. It establishes that both types of arguments can go into the rebuttal, so that qualitative and quantitative arguments can go into the rebuttal, as long as they relate in some form or some shape to the quantitative thresholds set out in Article 3.2 of the DMA. In this same vein, the General Court also holds that the only exclusions set out in recital 20 are those related
Hello, kindly mute yourself.
To the gatekeeper's capacity to set forth arguments based on the market efficiencies or justifications on economic grounds to avoid the designation. Given that the DMA is also a separate and complementary instrument to EU competition law, and it is also particularly aimed at speeding these sanctioning proceedings up, economic arguments, therefore, did not serve as a touchstone in the DMA's analysis. And stemming from these thoughts, the General Court also recognizes that the standard of proof that the gatekeeper must surpass to try to escape from the DMA's designation process and the DMA's provisions, when the quantitative presumption has been applied by the European Commission, is that of a high degree of plausibility. The gatekeeper, therefore, must call into question the application of the presumption in light of this legal standard. Thus, the General Court declares that the European Commission's application of the legal standard for the rebuttal was consistent, even though it does examine the merits of the European Commission's interpretation relating to each one of those legal requirements for the designation of the substantiality, criticality, and durability. On that same note, Article 3.1 which is the substantiality requirement, establishes that the undertaking must have a significant impact on the internal market. The legal requirement is directly correlated, therefore, to the quantitative presumption embedded in Article 3.2 that you'll also find in the slide. The European Commission must therefore demonstrate that the gatekeepers European Union turnover is equal to or above 7.5 billion euros in each of the last 3 financial years, or that it's on one side, its average market capitalization or its equivalent fair market value amounts to at least 75 billion in the last financial year. In the European Commission's designation decision, the European Commission demonstrated that TikTok surpassed the threshold relating only to its equivalent fair market value. However, also ByteDance contested the application of this threshold on 3 different fronts. It first argued that although it did meet the threshold, it could in any case contest the designation by demonstrating the limited turnover that it bears with respect to the European Union. The General Court did back ByteDance's interpretation because the thresholds set out in Article 3.2 that displayed in the slide are alternative and not cumulative. But that does not automatically mean that the gatekeeper cannot make that argument for the rebuttal. Moreover, ByteDance also argued that its fair market value basically derives from its operations in China. So the European Commission could not rely on the value to measure its impact on the internal market, that is the European internal market. The General Court did disagree and set forth that this particular threshold is not particularly focused on any given geographical area. And furthermore, the General Court also highlights that ByteDance could have argued as a means of the rebuttal the existence of these cultural and regulatory barriers in the EU vis-a-vis those in China. Moving forward to the second threshold, that of the criticality of the undertaking, that particular requirement sets out that the undertaking must be an important gateway for business users to reach end users, which is correlated with the quantitative presumption that you'll find in the slide. The provision establishes that these cumulative thresholds relating to the number of business users and end users active only in the core platform services that the European Commission wants to capture. To the effect, therefore, of rebutting the fact that it is not an important gateway for business users to reach end users, ByteDance and TikTok set forth 2 different arguments. First of all, it set out that it does not have an ecosystem to try to leverage its data and strength across different services, and that most of its users multi-home across different services and 2 other social networks. In this context, the General Court indicates that the gatekeeper did not prove or provide sufficient evidence that any of those characteristics did play a part in the configuration of its service. Instead, the General Court does set out that similar arguments to those of the ecosystem or multi-homing can go into the rebuttal, and they are quite similar to those reasons relating to economic justifications that may be put forward by the undertakings. For instance, the General Court provides a few examples, such as the benefits or the disadvantages created by the absence of the existence of digital ecosystems, or, for example, the intensity of multi-homing within those same core platform services. In any of both cases, the General Court highlights that the gatekeeper could not present those arguments once the administrative procedure had been completed, because that particular fact would undermine how the DMA is construed from its starting point, setting it as complementary from competition law. And the last requirement relating to that durability compels the European Commission to show whether the undertaking enjoys an entrenched and durable position in its operations derived from the fact that it meets the two thresholds we have just seen for the last 3 financial years. The General Court therefore established that this criteria aims to capture the undertaking's low contestability and whether that particular position is sufficiently stable over time. And finally, the General Court also responded to ByteDance's allegations that the European Commission had not performed a holistic assessment. In that sense, it is true that the European Commission did examine each argument as a standalone to check whether it surpasses this high standard of proof that we have previously seen of the sufficiently substantiated arguments manifestly calling into question the presumption. And to finish up my presentation, I also wanted to provide a few thoughts on how, in my own view, the two main rules proposed in Africa could be interpreted in case a designation process was to be applied. On the side of the draft COMESA regulation, it is not particularly aimed at capturing undertakings designated as gatekeepers in the fashion of the asymmetrical regulation concept we have just seen. It does not impose additional or distinct obligation to those undertakings, but it perhaps applies in a different way when examining these findings of an abuse of economic dependence. In that sense, the concept of a gatekeeper does remain undefined, so it is also possible to diverge from the DMA's concept of what a gatekeeper is. On the side, however, of the AfCFTA Protocol on Competition Policy, Article 11.4 does seem to introduce a sense of asymmetrical regulation into the legal framework of the gatekeepers. It is true that particular obligations apply to those gatekeepers that do not apply to regular undertakings. However, the same procedure does apply to these types of undertakings as it applies to other undertakings being sanctioned under sanctioning proceedings. As opposed to the COMESA regulation, these provisions do define the concept of a gatekeeper similarly to the DMA's terms. There is, however, I would say, some kind of scope for leeway for the regulation to consider whether to, for example, introduce presumptions or whether to consider both quantitative and qualitative considerations to go into that analysis. And finally, the drafting of the protocol also seems to point to the fact that the designation may be operated alternatively with respect to gatekeepers and core platform services. Therefore, it may well be the case that the regulation may not need to designate core platform services corresponding to those gatekeepers. And perhaps its scope may be more all-encompassing, since there is no list of core platform services included in the protocol, as there is, for example, in the DMA. I would say that it can also apply to a wider range of services than the DMA. For instance, this type of regulation could capture generative AI and its application to the tech sector. And finally, I also wanted to provide you with a few of my recent publications on the DMA, and we can talk about any one of them, but also I would be glad to discuss further with you. And thank you so much for your attention.
Oh, wow. Thank you so much, Alba, for this presentation. I think, and the participants will agree with me that we've learned a lot, especially on the concept of gatekeeper power. We've learned a lot about the battles that platforms may raise in future when these kind of regulations begins in Africa. So I have a number of questions, and I'll also invite the audience to ask questions. And my first question is relating to what really is gatekeeper power, because I think you missed to really give us the background of what is gatekeeper power. And does gatekeeper power mean bigness? And when you look at the AfCFTA Competition Protocol, they're talking about abuse of economic dependence. What is really abuse of economic dependence, and how does it relate to gatekeeper power? That's my first question. My second question, if you have any information on the legislative process that led to the EU Commission deciding that we are going to have a different regulation, that is the Digital Market Act, that will complement the EU competition law, and why they decided to reduce the scope to digital gatekeepers and the specific core platforms. Just as you mentioned, under the AfCFTA, it seems like we are not having a limitation of the core platform services. So what should these other regimes look into? Should they also limit the core platforms when they start adopting the regulation or not? The third one, when we look at the EU regulation and maybe India and also the UK, it seems like they want to have a different kind of regulation. But when you look at the African regulation, we are having provisions under the general competition law legislation. The Nigerian Federal Competition and Consumer Protection Act has a provision on how it's going to determine abuse of dominance in digital markets. The Competition Authority of Kenya now has a legislative proposal on how it's going to regulate digital markets and so on. We've seen Egypt also regulating this. So when they're going to determine the relevant platforms to regulate, should they use competition law methodologies of determining relevant market power, or should they go the EU way of looking at the quantitative and the qualitative measures? I think those are three questions are the most important now for me, and then we'll listen to the audience as well. Thank you.
Thank you so much, Vela, for your question. I would say that those are really big questions. On the first one, the gatekeeper power, I would say that as we have seen with the thresholds of quantitative presumptions, those thresholds are basically based on bigness. So we have, for example, turnover, that is bigness, number of business users, and then users, again, that's bigness. I would say that also if we turn to the legislative process underlying the DMA, we can also get some clues on what the legislator tried to capture, because underlying all of the DMA is this idea that it must remain complementary to the nature of competition law, because the DMA in itself is also based on both contestability and fairness, which are not quite the same as promoting or protecting an undistorted system of competition, which is quite different, because the DMA also tries to address contestability in the sense of trying to lower barriers to entry and to expansion to these digital markets, as well as to address fairness issues, such as, for example, the existence of imbalances in bargaining power or in the rights and obligations of some business users relating to the gatekeepers. So here we see how the legal interests that went into defending and to promoting the passing of the DMA are quite different to what we have in competition law. Also on the side of how do we define abuse of economic dependence, as we were also discussing earlier, Article 102 does not really have a manifestation of abuse of economic dependence as such. The only manifestation that could be quite similar to that of abuse of economic dependence is the first 102A, which represents the prohibition of imposing unfair trading conditions upon the undertakings. And that is quite, I would say, quite a striking or quite peculiar provision to apply, since the European Commission, since the articles 101 and 102 in their forms throughout history have been applied. The European Commission has tried to not apply them or to not demonstrate what unfair in that context means. In fact, in the side of fairness, the European Commission, once it has also reviewed all of its competition policy relating to how it is going to apply the DMA, because also I wanted to say that the DMA is not maybe aimed at covering every single service and every single problem within digital markets, but it aims to address those elements that are most problematic, because there's that lack of contestability and that lack of fairness within the list of core platform services that we have seen. And that's why the legislative process conduced to the designation and to the listing of those core platform services, as opposed to other ones. For example, now there's and that's why I included that comment at the end of the discussion, on the sense that now the European legislator is also trying to circle back on whether we should also incorporate generative AI, because there's already a low contestability on the market. So maybe the DMA can be expanded to that particular market, but as it is now, it does not apply directly, at least to generative AI. And circling back to what I was saying on the concept of fairness, the European Commission, since not everything is covered under the DMA, there are some conduct that can go into being sanctioned under antitrust sanctioning proceedings. The European Commission fined Apple for its conduct that it conducted in the past, that is, before March 2024, before the deadline of compliance of the DMA, for a conduct that is really similar to that of one of the provisions of the DMA, which is Article 5.4, which is the prohibition of the anti-steering provisions. Basically, that Apple cannot hinder app developers to not to really communicate directly with their users without taking recourse to their own payment system. And there, in that particular case, when the European Commission fined Apple for that particular conduct, it did put forward that fairness is different in antitrust, is different to that we find in the DMA, but that a really great indication of the unfairness of those conducts was precisely pointed at by the fact that those same conducts were captured by the DMA. So it's quite a circular line of reasoning for the moment being. Also, on the legislative process, we already also had this, I would say, process of discussion on whether we should maybe enhance competition law, as you're doing, as a result of these problems that digital markets pose for competition authorities, or whether a different ex-ante regulation should be adopted as a result. And that's maybe what most of you will have seen in the last few years referred as the new competition tool that the European Commission and the European Union tried to introduce in the European Union set of antitrust rules. And that particular tool was particularly aimed at introducing market investigations to try to determine whether those particularized or specific problems with regards to competition, that is, not contestability and fairness, competition, demanded specific remedies to be imposed as a result. In fact, national competition authorities, that is, those competition authorities of the member states, such as Spain, Italy, France, some of them have already adopted those types of market investigation procedures to try to curb also the market power sustained by these dominant undertakings. And finally, if we were also to have this, circling back to your third question, if we were to also incorporate this type of designations of gatekeepers and of this type of tech regulation for gatekeepers under antitrust, I would say that if the same procedure is going to apply, then definitions of relevant market would be particularly, in that sense, relevant to incorporate into the designation process. But maybe the sole designation of the gatekeepers may also warrant some kind of maybe developing some kind of guidelines to try to maybe soften those relevant market rules to adapt to the digital dynamics. Because, for example, in the European Commission, and in the European Union, there has been a redrafting of the market of the market definition notice, and there have been some minor changes of how we should analyze those markets and digital markets. And those really don't seem to be quite enough to try to capture them, because they have been, in that sense, they have incorporated network effects in quite a static perspective, and ecosystems as only like the accumulation of different markets, whereas ecosystems and digital ecosystems do not quite function in that way. So I hope that those explanations do answer your questions, and I'm happy to take any more of them.
Okay, thank you so much. They've answered my question. Then we have a question from Mr. Kumar in the chat. Is asking why any cloud computing services provider was not found fit to be designated gatekeepers under the DMA, the cloud computing services.
Yeah, thank you also for the question. So there's also two arguments to the question. First of all, we can more or less say that cloud computing services are captured via the DMA, because when the European Commission captured and designated Microsoft for its operating system, Windows Client PCOS, it did include the different formats in which the PCOS operates. So as, for example, the Azure Virtual Desktop operation on the cloud is incorporated into the definition and the designation of the service under the DMA's procedures, so that in some way cloud computing services are included. But indeed, I would have expected, for example, that Amazon Web Services should have been included under the designation. It may well be the case that the European Commission does that, for example, via the qualitative designation, or maybe when, I would say the main reason because they were not designated was that the undertakings must submit their notification to the European Commission if they really meet those thresholds. So maybe it may well be the case that those services did not meet the quantitative thresholds, and in parallel, the European Commission does not maybe consider that they are sufficiently relevant to analyze them via the qualitative designation means, because they do not have those low contestability levels as other core platform services have at the moment.
Okay, thank you so much. And those might be some of the reasons why Samsung was not designated as a digital gatekeeper. Okay, thank you so much. Anyone was a comment, a question of clarification, you want to know something, you can just unmute and ask. We have at least 8 minutes to go. Yeah, so as we think about the question, I was taking some notes on what the African region can learn about the issue of regulating digital markets and which platform to regulate specifically. And some of the issues I was noting is that gatekeeper power is a form of power in which an undertaking controls access either to its customers or also to its products. So it's the effect of controlling access. So if end users want to access business users, they have to use this platform. If business users want to access customers, they have to use this platform. So it controls access to its users, to third parties, and also controls access of its product and content. And because of that control, then those who are on this platform, they have a problem of either switching to other platform, or there's an issue of side homing rather than multi-homing. And you realize that in the instance of digital markets, now we have what we are calling the lock-in effects because of the network effects. Network effects simply means the value of product increases with the number of users who are on those specific platforms. So So gatekeeper power is not really about the bigness. It's about how the specific characteristics of these platforms, especially control of access to the infrastructure, whichever infrastructure. And I think the issue of gatekeeper power was used in the telecommunication industries a lot, especially in the EU. So when I was looking at when Alba was talking about the TikTok decision and the arguments that the TikTok decision, that TikTok used in order to rebut the designation of it being a digital gatekeeper, and when it argued that it didn't have union turnover for it to be able to fit within Article 32A, I think 32A, on the issue of it not having the union turnover of 7.5 billion of its turnover in the EU. And then it argued that although it was having the global turnover of more than 75 billion in the last 1 year, most of this turnover was being accrued in China. And I kept asking myself, if the AfCFTA or COMESA or the ECOWAS Competition Authority, CEMAC, or the West African Monetary Union is going to regulate digital gatekeepers, then we really have to rely on this decision, because these platforms may argue that we are not accruing the amount of turnover you're trying to say under the African continental market. Therefore, we don't have a link within the African continental market. Therefore, we cannot be regulated by the digital regulation that we are having. So that means that if we are going to look at this, we also have to have an aspect of ensuring that we are able to capture the element of taking into consideration the global turnover of this platform. Then, of course, the issue of the legal standard of proof is very important as we adopt this regulation. And another important issue, and Alba, you've written a lot about this, is about the scope of application of this regulation. So as we talk about who is going to regulate specific digital platform or specific core platform services of particular digital platform. So for the AfCFTA, it's going to regulate issues that only have a continental dimension. COMESA and other regional competition authorities like ECOWAS will focus on regional dimension. So we have to have room for the national competition authorities also to be able to regulate their digital markets. Then the question of abuse of economic dependence, that's why I really wanted you to talk about it, because abuse of economic dependence is all about a situation where undertakings do not have sufficient or reasonable alternatives, and because of the market structure, they cannot shift to other platforms or other undertakings because of various reasons, like the network effects within the African market ecosystem. But then this is a very prevalent behavior in the market digital ecosystem, because most of the businesses are economically dependent on digital platforms, especially the Google search market, because it's the first step for consumers to reach businesses. So they have become economically dependent. These platforms have become their only source of revenue, and they have an equal bargaining power even with international platforms or international businesses. So I think the idea of COMESA competition regulation or the AfCFTA Competition Protocol, including the provision of abuse of economic dependence in digital markets, was very well thought of. And then finally, the other thing I thought about is remedies and appropriate remedies when it comes to the issue of digital market regulation. Let's think about the recent case of the Federal Competition Commission of Nigeria regarding the misuse of Nigerians' data when it came to the WhatsApp privacy, their privacy platform, whatever. So you realize that if you're following the case, and WhatsApp has now appealed to the tribunal regarding the issue of whether they were going to pay the fine or not. And there's a lot of discussion about whether the fine that has been imposed by the Nigerian Federal Competition and Consumer Protection Commission is appropriate, and even whether WhatsApp will have to pay that, because we are talking about an African country going after the big tech companies. So those are some of the issues that I was able to just think about as Alba was talking about this important topic. And I think as we continue having an effective enforcement or regulatory framework towards the regulation of digital markets, these are very important questions that we are going to think about as we do this. So I don't know if we have another question. A final one from Navid, who says, we know it's too short a time to evaluate the impact of DMA, but what, in your early sense, how is it making digital markets contestable? That is.
And I also believe that there's a hand.
Okay, maybe
from Tula.
Okay, yeah. Tula.
Sorry, should I go this? Can you hear me?
Yes, we can hear you now.
All right. Well, just want to thank Dr. Alba Martínez for that very useful presentation, very insightful. And I think the issue of asymmetric regulation is one of the things that I think is quite interesting as a concept. And I note that a number of competition authorities, including COMESA, are coming up with guidelines. I'm not sure to the extent to which, of course, you can implement guidelines which are not supported by a law. And I think in countries where they do not have proper provisions in the legal framework, that they will need to do some amendment in the main acts to accommodate matters to deal with asymmetrical regulation, because there could be constitutional challenges if they just come up with guidelines which are not standing on the law. But I think the different scenarios that you've provided for the UK, Germany, and the EU, I think they provide very useful parameters which member states in COMESA, ECOWAS, the East African Community may to look at and see how they can sort of get on the bandwagon and not be left behind. And I think we are grateful to the work that Vela is doing in this regard to sensitize competition authorities. And of course, for us who are in the private sector, to also be alert and aware and make our clients aware of the developing framework at continental level as well as the international level, of course. So thank you very much for this insightful presentation.
So thank you also for your comments, and also building upon what Nivan, I believe it was, Navneet. So the early effects of the DMA and its solutions, I would say that the early effects of the DMA have really been that the gatekeepers have now been forced to introduce compliant solutions abiding by the rules of the DMA, which are quite similar in the African tech regulation, to the European Union. Like maybe the most controversial point is that most of them only apply to the European Union because the regulation compels them to do that, but they have not projected this Brussels effect that sometimes we talk about on how regulations and solutions transpire to other jurisdictions. So maybe the good side of this first impacts of the DMA that we have seen is the fact that if the gatekeepers have really moved their business or transformed their business models according to the DMA's terms, they can do so and they can replicate those same business models within the jurisdictions that do really regulate in that aspect. And I would say that in also circling to Tula's comments, I would say that the principle of legality is also a key touchstone for regulating all of that matter.
Okay, thank you so much. Boniface Makongo has a question as well.
No, I don't have a question. I just want to thank you very much, Vela. I just want to clarify with regard to the principle of legality is that in the context of COMESA, what you're trying to do is to amend our regulations to provide for both contraventions relating to gatekeepers and abuse of economic dependence. It's not a regulation, it's not guidelines. Just to clarify that. Thank you.
Oh, okay, so much. Boniface is the legal officer at the COMESA Competition Commission. So I have a final question because I think our time is not on our side. So in your experience, Alba, what have been the weaknesses of the DMA and how can African countries learn from these weaknesses? Because I don't think it's all good about the DMA. Let's know about the weaknesses in regard to designation of digital gatekeepers.
I can maybe talk for 1 hour on this question, but I will keep short and maybe to present and set forth two different ideas. I would say one of the main issues is the fact of fragmentation, because we also have, and I would say that in the context specifically of the AfCFTA, it's also key to also understand that the DMA was also passed and adopted not on the legal basis, also talking about the principle of legality, not on the legal basis of competition regulation, but on the legal basis relating to the addressing of the fragmentation in the internal market, because the different member states were adopting different legislations similar to the DMA. For example, the French had proposed and the Dutch had proposed similar proposals, and then the union came together and adopted that regulation. However, since that it is based on the addressing the fragmentation of the internal market, we are already seeing that the harmonization of the internal market is not quite fructifying for the moment. On one side, we already have these German rules that apply to the same gatekeepers and with similar rules to those of the DMA. For example, the German Competition Authority already applied one case relating to Google's processing of personal data, and it basically replicated the same remedy that Google had applied for its core platform services to the rest of its non-core platform services. So it just completed the application of that prohibition to the rest of services operated by Google. And the second one that I would say is really important to try to really capture how we are going to try to curb and to try to address tech regulation is the fact of objectives. And in the DMA, we have really suffered from the fact that the DMA was first designed around these ideas of contestability and fairness, but it was not until the last draft of the proposal, that is the final text of the proposal, that we knew what contestability and fairness stood for. So that is quite surprising, since it seems as if the European legislator was operating and legislating based on two concepts that were not really defined under the regulation. And I would say that those are two of the main ideas. I would say that maybe African regulators should pick up in regulating tech, and also to try to implement these tech regulations based on two different decisions, be that through competition regulation and incorporating those technicalities and particularities to the competition law, to their own competition law regimes, for example, via the abuse of economic dependence, or via a separate regulation that can also deliver on results, but we also will have to see during the coming years whether those are really effective or not.
Okay, thank you so much for raising those issues, fragmentation and the issue of objectives. I'm writing a paper which is in the final stages on objectives of competition on the share of digital markets. And I've always been thinking about the goals of competition law in Africa and how it will relate to the goals of competition law regulation in digital markets, especially the issue of inclusivity and equality, and whether these principles go beyond fairness and contestability. And honestly, I was here to learn, and I hope everybody has learned. And therefore, we've now come to the end of this session and would like to thank Alba for giving us an opportunity and a chance to listen to you and to learn a lot. And we are looking forward to collaborating more on this important topic and to learning from the experiences of the EU, other regions, and how to have regulations that will be tailor-made to fit the market realities of different regions, while at the same time addressing the global issues pertaining digital market regulation. Thank you so much, everyone, and then we'll stop recording.
Thank you, Bella.